Such a pretty song. Naaseh Adam by Zusha, the final song on their new album, Open the Gates. Let's light up the darkness. Who is with us on a Thursday night with Shabbos almost here? Shandora in the Bronx, Melissa in Great Neck, Nancy in North Carolina, Steven in New Hampshire, Yehuda in South Carolina, David in Indiana, Pauline in Chicagoland, Rochelle in Modesto, Renee in Indiana, Guy in Ohio, Karen in Northern California, Paula in Chicago, Bella in Florida, Jose in Miami Lakes, John in Maine, Gwen in Michigan, Paul in the Great Northwest, Patrice in Utah, Paula loves the song, James in Indianapolis, and Lynn in North Texas. Welcome, everybody. Today's episode of AT Daily is sponsored by my good friend, Rabbi Reuven Wolf, in honor of my dear friend Sal. Thank you so much, Rabbi Wolf, and may you be strengthened in your beautiful and important work. Rabbi Wolf was on our podcast. It's a great episode. If you ever have questions about what Judaism has to say about Mashiach, about the Messiah and the coming of the Messiah, may it be today, if not tomorrow, listen to that podcast. Just look for the Accidental Talmudist podcast and the Rabbi Wolf episode, Who is the Jewish Messiah and when is he coming? Okay. Let's get into today's daf. We're on page 31 here in Tractate Yevamos, the 14th volume of the Talmud. We are in chapter 3. And today, continuing our discussion of Mishna number 8, which deals with certain kinds of uncertainty and the consequences of that uncertainty. So this whole chapter is about applying the laws of yibum that we learned in the first two chapters to specific situations, and then looking at all the variations and nuances to see, do we really understand the law well, and how would it come out as the sages sort of vary who's married to who and when were they married, and are we certain they were married? Right, because when there's an uncertainty, so then you have this difficult situation where perhaps a woman, for example, is the co-wife of a prohibited relative to the Yavam, right? So a man died childless. He had two wives. One of his wives is related to the surviving brother through some other relationship, and therefore they're prohibited to marry. And then the co-wife is exempt as well, and the two wives would go their own way, and there would be no yibum or chalitza. But what if the woman who would turn out to be the prohibited relative, if there's uncertainty whether she was actually married to the brother who died or not? Right? Maybe there was a betrothal that was uncertain, so we're not sure if there was a marriage created. Maybe they were married and there was a divorce, and the divorce document was deficient, or we're not sure if the divorce document was actually delivered to that wife. So in that case, if she is divorced, then the co-wife would come before the Yavam for yibum. She's not exempted. She has no other mitigating relationship, no relationship that would prohibit her to the Yavam, so they could perform yibum or chalitza. But if that divorce did not go through, then at the moment of death, there were two wives, and the co-wife of a prohibited relative would be exempt. So very different outcome. And if we're not sure what the outcome is, how are the sages going to deal with that? That's the subject of this Mishnah number 8. Now, generally, what we've been seeing is, a kind of recurring theme, basically a principle, but not exactly, that in these cases of uncertainty, they're not going to allow yibum, but they're going to require chalitza, so that the wife who's in this situation, or the Yevama who's in this situation, they're not going to allow yibum because she might be prohibited to perform yibum. They're not going to let her go as exempt because she might not be released and be permitted to other people of the public to go marry whom she wants because she hasn't been released through that chalitza ceremony. If she is exempt and they perform chalitza, well, really, there's no harm done. The chalitza was meaningless. And so, in these cases of uncertainty, usually the sages will prohibit yibum and require chalitza. So let's see how this plays out. Yesterday, we were looking at this case where there was a betrothal or a divorce. They were uncertain. There were a few different reasons given why the betrothal or the divorce was uncertain. In the case of the betrothal, they said that there was an object that was going to be used for the betrothal. And people were commenting, I think a little later, and I didn't address it, like, what a rude, shockingly rude way to divorce a woman or to betroth a woman, that you would throw the document of divorce, the get, at her, or that you would throw the object that she's supposed to receive and that symbolizes that the betrothal has been done, and you would just throw it at her. Well, of course you wouldn't throw it at her. The point isn't to throw it at her. But in this hypothetical situation where the sages have ruled elsewhere that sometimes it's impossible to hand her the document or the object, but if you can at least send it into an area that is defined to be her domain, right, the 4 cubits around her, then it would be like she received it, and it would be a valid delivery of the get or a valid delivery of the betrothal object. But if they were exactly 8 cubits apart, and you're not sure whether it sort of crossed the halfway point from your domain into her domain, that would be a case of uncertainty in the betrothal. And with the cases of divorce, it was that the bill of divorce itself, the get, was somehow deficient. Either there were witnesses, but they didn't sign it, or the writing itself was deficient, the date was left off, the name of the witness was left off, some kind of deficiency in the document of divorce, which creates that uncertainty about whether the husband and wife actually were divorced or not. So we picked this up at the very bottom of 30b. Now, sometimes another man might come and betroth the forbidden relative herself with a betrothal whose status is certain. And since the master rendered it prohibited for the co-wife, the rival wife, to enter into yibum, right? They said in cases of uncertainty, she must perform chalitza, but she's prohibited from performing yibum. So they prohibited the rival wife to enter into yibum. So people would say that the betrothal of the first man, i.e. the brother who died, was a fully effective betrothal, and that the betrothal of the latter man who comes along later was not a valid betrothal. So if she was married to the first man, then she is forbidden to the second man because she's still married to the first man, and betrothal cannot take effect with her. However, since the status of her betrothal to the first man was uncertain, then she is also considered possibly betrothed to the second man, and she would require a divorce from him as well. As a result, one can find a situation that would lead people to think that a man's wife, who's prohibited to everyone, is in fact permitted to others. She can go marry someone else because of this uncertainty whether she's actually married to the first guy. And that is an untenable situation. So Rabbah answered, since you require chalitza and you do not exempt her completely, all will know that this is merely a stringency and that the sages did not decide with certitude that the first betrothal was fully valid. Rather, just because it might be valid, and that there was a marriage to what is then a prohibited relative after the brother dies, that you're going to require the co-wife that she must perform chalitza. If it was in fact a marriage, she would just be exempt. But because it's uncertain whether that marriage happened, you're going to make her perform chalitza, because if there was no marriage, she would be suitable for yibum with the surviving brother. But because there's this required chalitza, here the sages are saying, well, if the public will know that they didn't have an option, they didn't perform chalitza as an alternative to yibum, it was a forced chalitza, a required chalitza. When does that happen? When there is a case of uncertainty. So you don't have to worry that the public will get the wrong idea. But Abaye raised a challenge. If so, let the Mishna teach the case where it is uncertain whether the item is closer to him or closer to her with regard to divorce, and stipulate that she requires chalitza. And they would know that this is merely a stringency and not make a mistake. At the end of yesterday, they were just debating, like, why is it that in the case of betrothal, they talked about whether it was delivered into her domain or not, but in the case of divorce, they speculated on whether the document was a valid document or not. Why not teach the same case? That in the case of the betrothal, uncertain whether the object reached her domain or not. And in the case of divorce, uncertain whether the bill of divorce reached her domain or not. And here we're getting some analysis of why those cases are actually different. So he answered him, a mistake could in fact be made here. As if you say that she must perform chalitza, then she may also enter into yibum. Right? Like people normally think that chalitza is an alternative to yibum. If she can perform chalitza, she could also perform yibum. And people will lose track of the fact that no, she's required to perform chalitza because of that uncertainty, and because of that same uncertainty, she may not perform yibum. But if all they heard is, hey, she's performing chalitza, then they might think, oh, well, actually, she could perform yibum, and in this analogous situation for another party, well, she performed chalitza, let's us perform yibum. And that would be a mistake that arose because people watching these events unfold don't have complete information. But the sages are always afraid that people will make mistakes due to incomplete information, and that's why sometimes they build that fence around the Torah a little wider to protect people from making such mistakes. People might mistakenly think that if she is suitable for chalitza, then she's also suitable for yibum. And as a result, the woman might enter into yibum despite the fact that it is forbidden for her to do so. Abaye objected. Here too, in the case of uncertain betrothal, the concern exists that if you say that she performs chalitza, then she might also enter into yibum. And Rabbi answered, so let her enter into yibum. And there is no problem with that. In this instance, she remains with her presumptive status as permitted because she was originally assumed to be permitted and was rendered forbidden only due to our concern for this uncertainty. However, there would be no actual transgression involved even if she were to enter into levirate marriage, because we might say there's an uncertainty, but it's a case where the presumption is that, I guess it must be that her co-wife, who would be the prohibited relative, was divorced. Now you're raising an uncertainty, was the divorce actually valid or not? But the presumption is that the divorce was valid, and therefore this co-wife can perform yibum. Because you're a little uncertain about that divorce, you're going to force her to perform chalitza, but why should we remove her from that permitted status where she could perform yibum with the yavam just because of that uncertainty? In the case of uncertainty, we should require certitude before we remove her from that presumptive status, right? Maybe we should be a little bit more lean. So is it a leniency or is it a stringency? Sort of depends on how you look at whether the outcome is desirable or not. Now, Abaye raised an objection to Rabbah by citing a case where even in places of doubt, the woman requires chalitza. And here we get to the curious case of the collapsing house. As we learned in a Mishna, it's going to come up in our tractate on page 67, but here's a preview. A house fell on him, meaning on a certain man, and on his brother's daughter to whom he was married. So he married his niece. That's biblically permitted relationship. He married his niece, and the house fell on them. They hadn't had a child together. He had never had a child, period. And so now the issue is who died first? Because if we knew that, right? If we knew that he died first in the collapsed house, okay, then at the moment of his death, he was married to this wife who happened to be his brother's niece, and his brother could not marry her. And he was also married to this other woman, the co-wife, the rival wife. And so because this wife who died in the house would, even if she hadn't died, would be exempt because of the prohibited relationship to the surviving brother, the co-wife would be exempt as well. However, if when the house collapsed, his wife died first, who was also his niece, so then she died. So then at the moment of his death, he only has one wife, right? At the moment of his death, if we knew this to be so, then he only had the unrelated woman, and she would come before the surviving brother for yibum, because there is no co-wife who is a prohibited relative to exempt her. But we don't know who died first, right? That's what makes this case distinct. We don't know who died first. It is unknown which of them died first. So if the deceased wife had a rival wife, then her rival wife must perform chalitza and may not enter into yibum. We don't know who died first. We don't know what the status of the co-wife is, whether she's exempt or permitted to perform yibum or chalitza. And so what do? They say she must perform chalitza. That's going to cover the bases. If the man had died first, then at the time of his death, the rival wife was forbidden to the Yavam as the rival wife of his daughter and exempt from levirate marriage. If, however, the daughter had died first, the daughter of the Yavam, who was the wife of his brother, if the daughter had died first, then at the time of the husband's death, the second wife was not the rival wife of a forbidden relative, and she requires yibum, or in the alternative chalitza. It is due to this doubt that we force her to perform chalitza and prohibit her from performing yibum. And according to Rabba's opinion, why is that so? Here too, let us say this woman, the rival wife, has the presumptive status of being permitted to marry a man from the general public, and this is because she was exempt from levirate marriage for the entire period of her marriage as the rival wife of a forbidden relative, right? So like, we don't know who died first. So the presumptive status is before that house collapsed, she was married to a man who had another wife, that he had two wives, and that wife was, related, a prohibited relation to the surviving brother, to the Yavam. So the last we heard, this woman is the co-wife of a prohibited relative, and therefore she's exempt from yibum and chalitza, and she's permitted to go marry any other man. Why would we remove that presumptive status of freedom for her and say that no, she's not free to go marry any other man until she now performs this forced chalitza with her Yavam? Why would we remove her presumptive status due to this uncertainty? In cases of uncertainty, we should stick with the status quo, not impose a new condition. That's the argument being made. Here too, let us say this woman, the rival wife, has the presumptive status of being permitted to marry a man from the general public. This is because she was exempt from yibum for the entire period of her marriage as the rival wife of a forbidden relative. And due to the uncertainty whether her rival wife was the first to die, you come to render her forbidden and require that she perform chalitza. Do not render her forbidden to the general public because of an uncertainty, right? That is the answer. And if you would say here too, we rule more stringently due to the uncertainty. Nevertheless, this would be a stringency that could actually bring about a leniency. For if you say that she must perform chalitza, then she may also enter into yibum. Some people will think that she's qualified for chalitza, so she's qualified for yibum. However, it is forbidden to her to enter into yibum because she is possibly forbidden to the yavam as the rival wife of the prohibited relative, in this case his daughter. And therefore, she's forbidden like the daughter herself. That was Abaye's argument. Now Rabbah replies, in cases of divorce, which are common, the sages issued a rabbinic decree preventing her from performing chalitza due to a concern that if she were required to perform chalitza, then she may enter into yibum as well. In cases of collapse, which are not common, the sages did not issue a rabbinic decree because they did not introduce decrees with regard to uncommon matters. Alternatively, there is another reason to differentiate between the cases. In the case of divorce, where there is a forbidden relative who indicates that the rival wife is forbidden due to her status as the rival wife of a forbidden relative, and you require that her rival wife perform chalitza, people will say, the sages determined that this bill of divorce is a full-fledged bill of divorce. Consequently, they required her rival wife to perform chalitza. And people may come to consummate the yibum with the rival wife based on this mistaken assumption. For if the divorce had been a fully valid divorce to the prohibited relative, then yes, the Yevama, the sole remaining wife, who is not a prohibited relative of the Yavam, she could enter yibum with him, right? If the divorce was a good, effective divorce, they could perform yibum. If there was no divorce, she's exempt as the rival wife of a prohibited relative. It's this uncertain divorce where they're going to say, okay, she must perform chalitza, but she's not allowed to perform yibum. But people will look at that and say, hey, she's performing chalitza. It must be that the divorce was a valid divorce. So, hey, why don't you just perform yibum? Fence around the Torah to prevent people making that mistake. In cases of collapse, however, could the sages have determined who died first in the collapse? As it is known to all that there was a doubt that can never be clarified, it is clear that the sages required the rival wife to perform chalitza only due to this unresolvable uncertainty. Therefore, there is no concern that she would come to enter into yibum because she was also told to do chalitza. Because she was told to perform chalitza. And the Gemara asks, but did we not learn in a Mishnah about the case where it is uncertain whether the bill of divorce landed closer to him or closer to her with regard to situations of divorce whose status is uncertain? And didn't we learn in a Mishnah, in a case where his wife was standing in the public domain and he threw her the bill of divorce, if the bill landed closer to her, she is divorced. If it was closer to him, she is not divorced. If it was half and half, i.e. if the bill of divorce landed midway between the man and the woman, there is uncertainty whether she is divorced or whether she is not divorced. And we say, with regard to what halacha, with regard to what area of law, was the ruling said that she is both divorced and not divorced due to that uncertainty? And the Gemara explains that this affects two areas of halacha. The first is that if the man divorcing his wife is a priest, then because she might be divorced, she becomes forbidden to him due to the uncertainty that she may in fact be divorced through that bill of divorce. Consequently, he would be unable to remarry her. Right? A regular person who's not a priest, he can divorce his wife, and then they say, you know what, we shouldn't be divorced. Let's get married again. And as long as she wasn't with some other guy while she was divorced, Jewish law permits them to remarry. But if he's a priest, they're not permitted to remarry because a priest is not permitted to marry a divorcee. And the second ramification of this uncertainty, where they're going to deem her both divorced and not divorced, the second ramification is that if the woman being divorced was a forbidden relative to her husband's brother, and her husband died childless, then her rival wife would require chalitza. That's the case we're talking about here. And the Mishnah indicates that in this type of divorce, whose status is uncertain as well, the sages require the rival wife to perform chalitza, and we do not say that if you say that she must perform chalitza, she may enter into yibum. Here there is no such concern. And the Gemara responds, but wasn't it stated with regard to that Mishnah that this is referring to a very specific set of circumstances? It is Rabbah and Rav Yosef who both say the doubt here does not result from the facts of the case the facts of the case themselves, but rather from the conflicting testimonies and the inability to decide between them. Here we are dealing with two sets of witnesses, one of which says that the bill of divorce landed closer to her, and the other set of witnesses says that the bill of divorce landed closer to him. This then is an uncertainty in matters of Torah law. For in this case, there are two testimonies, each one complete by itself, and yet they contradict one another. Such instances are deemed to have the status of an uncertainty with regard to Torah law. And in cases of doubt with regard to Torah law, we rule stringently, whereas in cases of doubt with regard to rabbinic decrees, we rule leniently. And therefore, this ruling is stringent. But the Mishnah here is referring to one set of witnesses who were divided in their testimony and who could not clarify exactly what had occurred. This is considered to be an uncertainty in matters of rabbinic law alone, as there is only a single uncorroborated testimony, and in cases of uncertainty in matters of rabbinic law, the ruling should be lenient. And the Gemara asks, and from where is it known that the Mishnah here is referring to a case of uncertainty with one set of witnesses? The Gemara responds, it is similar to that of betrothal. Just as with regard to betrothal, it is referring to a case of uncertainty with one set of witnesses, so too with regard to divorce, it is referring to a case of one set of witnesses. There were two witnesses, but they couldn't agree what happened. And the Gemara wonders, and with regard to betrothal itself, from where is it known that the Mishnah is referring to a case of uncertainty that involves only one set of witnesses? Perhaps it is referring to a case where there were two sets of witnesses. Each set of witnesses brings valid testimony. Two witnesses who saw it and agree with each other. But there's two sets of witnesses that contradict each other. What do we do? And the Gemara answers, if the Mishnah is referring to a case of two sets of witnesses who contradict one another, well then let her enter into yibum. And there is no problem with that, as there are two witnesses testifying that there was never a betrothal. Therefore, both the cases of betrothal and divorce must be referring to a situation where there's only one set of witnesses and it's inconclusive. The Gemara challenges, how can one say that? After all, there are witnesses who are standing before us and saying that the object of betrothal fell closer to her, and so she's betrothed. Accordingly, she was betrothed, and her rival wife is the wife of a forbidden relative, and so the rival wife should be exempt. And yet you say, let her enter into yibum, and there's no problem with that? And furthermore, with regard to the fundamental difference between two pairs of witnesses and a single pair, the case of two pairs of witnesses is also considered an uncertainty in matters of rabbinic law, not Torah law. This is not considered to be uncertainty with regard to the reality of what actually happened. That would be a case of uncertainty in matters of Torah law. But rather, it's a contradiction between two opposing testimonies. In these cases, we say, place two witnesses against two witnesses and let the two testimonies cancel each other out. Therefore, the halacha would be, let the woman remain in her original presumptive status, right? Because these witnesses are going to come and say she became betrothed. Now, if there's no witnesses, then she was never betrothed, then her original state would be she's single. You're going to bring these witnesses to say a betrothal happened and she became married. But if there's another set of witnesses who contradict that set of witnesses and say, no, she wasn't married, so the four witnesses, the two sets of witnesses, cancel each other out, she should retain her original presumptive status that she's single and not married. The Gemara cites a proof for this. And this is just as it is in the case concerning the property of a man named Barshatya, who was referred to by this name because he would occasionally go insane. The case is like this. So Barshatya, right, is a guy who would from time to time go insane. Why does it matter? Because while he's in one of his periods of insanity, where everyone agrees that while he's in that, state of insanity, he is not fit to buy and sell property. And if you sold him something or bought something from him while he was insane, that sale would be voided. But if he was his normal self, then it's a good sale and it stands. So Barshatya sold property. Two witnesses came forward and said that he sold it when he was healthy and therefore the sale was valid. And two others came forward and said that he sold it when he was insane and so the sale was void. Rav Ashi said with regard to this matter, place two witnesses against two witnesses and let the testimonies cancel each other out. Therefore, there is no valid testimony to rely on. So therefore, we don't know if there's a sale or not. There's no testimony to rely on. So let the presumptive status of the land remain as it is, meaning he keeps the land, right? The sale, if the sale was valid, then he would lose the land, but we're not sure if there was a valid sale or not, so the property remains his. Since no substantiated proof was brought forth, the land remains in the hands of its current possessor. As such, the same should be true with regard to cases of betrothal and divorce, whose status is uncertain, and the woman should remain in her former presumptive status. We're on 31b. Rather, Rabba's understanding of the Mishnah must be rejected. And Abaye said, the Mishnah should be understood according to that which is written. His fellow speaks of him. A verse from Job 36:33. This principle teaches that a related case can be inferred from the single case cited. The Mishnah teaches the case where it is uncertain whether the item is closer to him or closer to her with regard to betrothal, and the same is true with regard to divorce if it is uncertain whether the bill of divorce fell closer to him or closer to her. Similarly, the Mishnah teaches the case of bills of divorce that were written in a questionable manner with regard to divorce, and the same should be true with regard to betrothal. The first Gemara after we read this Mishnah was, no, the cases of betrothal were different than the cases of divorce. Now they're saying, yeah, but the law applies the same. So Rava said to him, if you understand that the legal ruling in all of these cases is the same, and the Mishnah was written in the style of his fellow speaks for him, this case speaks for that case, then what is the meaning of the term this is that the Mishnah teaches? The Mishnah, in fact, emphasizes that this is a betrothal whose status is uncertain, and this is a divorce whose status is uncertain, which indicates this case is unlike any other, and this case is unlike any other. Rather, Rava said, all of the cases that exist with regard to betrothal, whose status is uncertain, exist in cases of divorce as well. However, there are some cases of uncertainty with regard to divorce that do not exist with regard to betrothal, as betrothal performed with a questionable bill is not disqualified. Accordingly, the term this is utilized in the Mishnah with regard to divorce is not specific and does not imply exclusion of the case where it is possibly closer to him and possibly closer to her. Rather, because the Mishnah teaches the ruling of this is with regard to betrothal, where it is specific, it teaches the phrase this is with regard to divorce as well. And the Gemara asks, and what does the phrase this is mentioned with regard to betrothal come to exclude? And the Gemara answers, it comes to exclude the matter of the date, which is not essential with regard to betrothal, as when one betroths a woman by means of a document, the date need not be written, unlike a bill of divorce. And the Gemara asks about this matter itself. And for what reason did they not institute that the date must be included in a betrothal document? This policy works out well according to the one who says that the reason the sages instituted that the date must be written on a bill of divorce is due to the profits, as the husband receives the profits from the wife's properties during the period of their marriage. It was necessary to write a date on the bill of divorce in order to know at what point his right to receive or sell these items was terminated. However, it was not necessary to include a date on the deed of a betrothal, as this document serves only to create a bond of betrothal. And there are no profits from a betrothed woman. He doesn't get a right to the profits from the land that is in her name until they actually consummate the betrothal and become full-fledged husband and wife. However, according to the one who says that the sages instituted the requirement of including the date in the bill of divorce due to a case where a man is married to the daughter of his sister, then they should institute that he must include the date in a deed of betrothal as well. For occasionally a man might marry the daughter of his sister, whom he loves all the more because she is his close relative in addition to being his wife. And if he knows that she acted licentiously while she was married to him, he might grant her a bill of divorce without a date, so as to save her from the death penalty. Were witnesses to come forth and testify to her behavior, she would claim that at the time of her licentious act, she was already a divorced woman. If this was indeed the reason for the sages instituting the requirement of including the date in a bill of divorce, then the date should be included in a deed of betrothal as well. For an undated document of betrothal could be utilized equally well to prove the innocence of the daughter of his sister. If she acted licentiously in the period prior to her betrothal, she would not be penalized. Therefore, the date should be written on this document as well. And the Gemara answers, Because there are those who betroth by means of money, and there are others who betroth by means of a document, the sages did not institute that the date must be written in the document, as the date of the betrothal has no place in the act of betrothal by means of money. The sages did not distinguish between the various modes of betrothal, as opposed to divorce, where there must be a bill of divorce. You can only divorce with a get. Betrothal, you can do without a document. So if there was a document, why would you have requirements on it that wouldn't be present if you did a betrothal without a document? So Rav Acha, the son of Rav Yosef, said to Rav Ashi, but with regard to a slave, where there are those who acquire them with money and there are those who acquire them with a document, the sages nevertheless instituted that the date must be written in a slave's deed of purchase. And he responded, well, there, with regard to slaves, the majority of people purchase them by means of a document. Here, with regard to betrothal, the majority of people perform betrothal by means of money. If you wish, say, a different reason why the sages did not institute that the date must be included in a deed of betrothal, and this is due to the fact that it is not possible to institute this in a manner that will ensure that no problems will result. How would we do this? If we leave the deed of betrothal with her, she will erase the date, and so it would remain impossible to prove the juncture at which her licentious behavior took place. And if we leave the deed with him, then there are times when she is his sister's daughter, and he might cover for her by erasing the date himself. I'm almost done. If you have questions, get them in. If we leave the document with the witnesses who signed it, if they remember themselves the date when the deed was given to the woman, the date need not be written in the document. For let them come forth and testify from their memory. And if they do not remember by themselves, then there are times when they see the date written and come forth to testify based on what's written in the document rather than their own memory. And the merciful one states, by the mouth of 2 witnesses or at the mouth of 3 witnesses shall a matter be established. And from this verse it is derived from their mouths and not from their writings, indicating that testimony is proper only if the individual stated it of himself and not on the basis of something that was written in which he read to refresh his memory. And the Gemara asks, if that is so, let us say that with regard to divorce as well. In cases of divorce, there should also be a concern lest the woman erase the date on the bill of divorce in her possession. The Gemara responds there, in the case of a bill of divorce, the date comes to save her. Since the bill of divorce removes her status as a man's wife, she therefore would fear erasing anything lest she disqualify the bill altogether, thereby possibly rendering herself a married woman again, who's prohibited to the whole world. And here, however, when dealing with a deed of betrothal, the date comes to her disadvantage, since until now she was presumed to be a single woman, and if there is no date on the document, then she clearly cannot be punished. And that concludes the Gemaras on Mishnah number 8. And with God's help, tomorrow, noon Pacific, the regular Friday time, we'll open Mishnah number 9 and page 32. All right, let's see if there are any questions or comments. On page 31. Gwen Strong, do these yibum marriage laws apply now? So I've looked this up, and it's interesting. Like, there was a very, very rarely, occasionally, a yibum performed, even as recently like as 100 years ago, 150 years ago, although it had become incredibly rare because most rabbis in the world adhere to the principle, I forget who stated it, that we don't want, I'm sorry, we had it in the Gemara. It was in our Gemara. Even the sages 2,000 years ago were studying these laws so we know what we're supposed to do in all these various situations. But the general choice is that if the couple have a choice whether to perform yibum or chalitza, they should perform chalitza because we worry that they don't have the proper kavanah, the proper intention. If there's at all kind of lust between the widow and the surviving brother, and they want each other, then he's not being with her in order to build up his brother's house, and he should not overcome the existing prohibition on ever marrying your brother's wife, right? If the brother had not died childless, then the surviving brother could never marry the widow. And so there was always a preference for chalitza, even in the times of the Gemara. And so yibum so rarely ever happened. But chalitza does apply. So that if, God forbid, a man dies married but childless and leaves a surviving brother, and everybody's Jewish, so they're supposed to perform that chalitza ceremony to release each other, really to release her, so that then she's free to go off and marry whoever she wants. Until she performs that chalitza ceremony, she's not free. So yes, these chalitza ceremonies do happen from time to time, even now. Bill. Okay, so I've mentioned that I've been struggling with how chalitza can be necessary when yibum is prohibited, but I think I've just about got it. Chalitza is required to cover all bases. Yes. Or am I still in the wilderness on this one? No, you basically got it. That's basically it. When they require chalitza, it's in those cases of uncertainty where either the chalitza is required to release her so she's free to marry whoever, or she was exempt, in which case the chalitza was meaningless, but really they just went through a ceremony that was unnecessary, but there's no consequence. Either way, it's like she was exempt or she did chalitza, now she's free to go marry whoever she wants, and is prohibited to the Yavam. Karen, isn't throwing things just a part of the sex is not touching? At my yeshiva, we were tossing objects all the time just for convenience. Interesting. I had not heard of or thought about that. Right? Because what Karen's referring to is that people are shomer negia, right? Since you never know if a woman might be a nida, right? So she might be having her menses, in which case, it's forbidden for her to even touch her husband, let alone anyone else. So, Orthodox people, Haredi people, men and women just never touch each other because you never know what the status is. And just the general shomer negia is men and women don't touch. Like they don't shake hands, they don't hug, they don't kiss, nothing. And so maybe this, handing an object or even throwing it into the domain is related to that. Interesting. I had not even thought of that. But when they're talking about those rules of whether you acquire an object or not, in this case, we're talking about, a document being acquired or the object of betrothal being acquired and whether a betrothal or divorce happened. Later, when we're in Bava Kama, Bava Mitzian, we're just talking about commercial laws, the laws of buying and selling, whether it's, objects in a store or land or all kinds of other commercial dealings or services. And we'll really examine whether something was purchased or not. Right? Did the purchase money go into his hand? Did it go into his domain? And so the technicalities, the requirements of acquisition are really what's being argued about here, not the motivation for why you used one method of acquisition versus another. But if you were just, throwing a document into someone's domain, it's not that dissimilar from being served a subpoena, right? Like there are certain rules where if you just refuse to take the subpoena from the process server, I don't know what the rules are, whether he could just actually touch your body with it or throw it at your feet in front of witnesses or, whatever those rules are, but it's similar to what we're talking about here. Sharon, this may be a simplistic question, but if there are two wives and one wife is of uncertain status, rather than making them perform chalitza, why couldn't the co-wife of certain status be the one who comes before the brother instead, and there be no question at all, right? Since only one of the wives needs to perform chalitza, one is uncertain status, but the other one, but see, because one is uncertain status, I see what you're getting at. So since we're really asking this question for the benefit of the rival wife who is either exempt or needs chalitza, why not just perform chalitza with her? Because there's going to be a certainty here. Or in cases where, with one of the wives you know what to do and the other one there's the uncertainty. But, they still need to work it out because it may be that wife is away. She's on an extended tour of Europe. And she's not available to perform that chalitza ceremony and won't be for a few years. And meanwhile, there's a wife right here, who'd like to go her own way and get engaged with someone else. So that might be a reason. And finally, Lucy, So was the betrothal document or the divorce get thrown at the woman rather than given to her because she was unwilling, so that if it fell within 4 cubits of her, she was betrothed or divorced nevertheless? It's basically the same question that Karen asked in terms of what was the motivation for using that method, and I don't know. But that's an interesting, excuse me, that's an interesting guess. Maybe she was unwilling to receive it because she just doesn't want to let the guy go. But, the time has come to end the marriage. And so, it's considered that if it landed in her domain, that's good enough. I suppose if it happened in front of witnesses. We don't know what the motivation is. The question is simply, did it happen or did it not happen? Was the divorce completed or was it not completed? But you might well be right that was the motivation for using that method instead of another. Okay, my friends, that's what I've got for us today. With God's help, we'll be together again tomorrow at noon Pacific for page 32. Have a great night.